Hey everyone, how's it going? I want to give a couple quick updates about things and then I'm going to jump into this episode. And I apologize in advance, this episode is going to be much longer than the normal episodes. But hopefully this will be self-explanatory in just a couple of minutes after I explain all of this. It's been a couple weeks since I actually put out an episode. The reason for that is, first of all, Thanksgiving break. And so we had a couple of classes right before Thanksgiving break that I still haven't recorded yet. And then we had Thanksgiving break. And then I actually fell ill over Thanksgiving break. So we had Thanksgiving and then that Friday, was it Friday? It's either Friday or Saturday. I became pretty sick. We went into Utah to see some family over the break. I got sick on our last day there and then started coming home, and I ended up missing the first couple days of classes that Monday and Tuesday, and I've actually frankly had a pretty difficult time getting back into the groove of studying all the material and all that sort of jazz. So I have several episodes to catch up on. I think if I remember correctly, I have one torts episode and one criminal law episode to cover before that occurred before Thanksgiving break. And since Thanksgiving break, I have 2 civil procedure episodes, 3 more torts episodes, and 1 more criminal law episode to go over. So what is this episode going to be all about? Well, tomorrow is my civil procedure final, and I want to give a huge overview of everything that we have covered this semester. It's going to be condensed for sure, but I do want to do this review for my own sake as well as anyone else who might hear this, just so that they can have an overview of how civil procedure works at the very bare bones minimum audio version that you can actually have of all this material. One last thing to note before I get into all this, though, is that I am actually still feeling a little sick. So if I cough, if my throat sounds a little dry, if I'm drinking water, that'll be the explanation for all that kind of stuff, because I won't edit any of that out. So that's what this is going to be all about today, is civil procedure and giving an overview. So what did we cover during civil procedure? I'm hoping this will be about half an hour long. It might be longer. It might be shorter. You never know. But civil procedure, the way it all starts is that you have a complaint. A complaint is filed by the plaintiff, and it is really it's how you start a lawsuit. I believe that's Rule 3 that says that. After the plaintiff files a complaint, they need to provide notice to the plaintiff. That notice is provided through service and summons. Both those things need to be given to the plaintiff. After that, if the defendant so chooses, and even the plaintiff could do so, but no, it'll be the defendant who does this. The defendant could remove from a state court to a federal court. After that, the defendant could transfer, or the plaintiff could transfer from one federal district court to another federal district court, in which an answer will be given by the defendant in response to the complaint. Those things need to happen before the answer, the removal or transfer, or else you waive that opportunity to remove or transfer. So in your answer, a lot of the time the defendant is going to file a 12B motion to dismiss. And they're going to file a 12B 1, 2, 3, 4, or 5, or any combination of the above. And so the extent of this episode is going to be going over each of these steps. We're going to talk about the complaint a bit. We're going to talk about notice, removal, transfer. We're going to talk about the answer. And specifically, we're going to be focusing on 12B 1 through 5. We're going to start in that order, where 12B 1 is motion to dismiss for lack of subject matter jurisdiction. Then we'll move into 12b-2, which is a motion to dismiss for lack of personal jurisdiction. And then we'll talk about 3, motion to dismiss for improper venue. And then we'll talk about 4 and 5, which is a motion to dismiss for insufficient process. And 5 is insufficient service of process. These last two things, are going to be focusing on notice. So we're going to go over all those things, and then at the end we'll go over a couple of miscellaneous things, such as removal. We'll talk about transfer when it comes to venue, and we'll talk about, actually, I still haven't caught up fully with civil procedure, so I'm missing choice of law. So I won't get into choice of law. That'll be the only thing lacking from this semester in this episode. Other than that, everything else should be covered, or at least given a broad overview of all the material. So let's go ahead and start with subject matter jurisdiction. There are 3 ways to find subject matter jurisdiction. You have federal question, you have diversity, and you have supplemental jurisdiction. Federal question jurisdiction is found underneath 28 U.S.C. 1331. Diversity jurisdiction is 28 U.S.C. 1332. And supplemental jurisdiction is 28 U.S.C. 1367. Let's start with each of those in order. So federal question jurisdiction, 28 U.S.C. 1331. How does this all work? Well, it starts with the well-pleaded complaint rule. I will be going over each of the cases briefly. I may just even only read the name and not talk about any of the details of the cases. And in fact, I won't talk about any of the details, just give the takeaways. We have the well-pleaded complaint rule, which is described in Louisville and Nashville Railroad Company versus Motley. What's significant about this case is that subject matter jurisdiction can be raised at any time, meaning it's not waived. So 12b-1 is not waived. It can be brought forth anytime. Any other thing, so 2 through 5, if the defendant doesn't bring it up in their answer, is waived. But subject matter jurisdiction is not waived. And that's one big takeaway from Motley, because this was a case heard before the Supreme Court, who determined that there wasn't actually even jurisdiction to begin with. Another takeaway from Motley is that the federal question must be derived in the complaint and not be as an affirmative defense. So what's a big takeaway rule? Is that the claim in the complaint must arise from or relate to the Constitution or any other matters of federal law. There is an exception to this rule, and we have a couple of cases that are trying to outline this exception, and only one of them has been successful in outlining this exception. First, we have Merrill Dow Pharmaceuticals versus Thompson. Here, it was a labeling case. It was not allowed, and that's because this was a private claim, and the private claim just meant that they weren't able to make this federal claim, whereas a federal law would have been able to. We have Grable and Sons Metal Productions versus Dare Engineering and Meetings. What happened here is that their claim would substantially alter tax law, and so it was allowed to be an exception to the well-pleaded complaint rule. And then we have Gunn versus Minton, where this person had a very similar fact pattern as Grable and Sons, where his case was dependent on federal law, but it would not significantly alter federal law, and as a result, it was not an exception. So our only exception to the well-pleaded complaint rule is Grable and Sons, and that is 1331 federal question jurisdiction. Now we have 1332 diversity jurisdiction. Diversity jurisdiction is always going to be a state law claim and has 2 requirements. First, there needs to be complete diversity, and there's going to be a mounting controversy that must be met. What is complete diversity? Well, Article 3 of the Constitution only requires minimal diversity, but 1332, even though it doesn't say complete diversity, the Supreme Court has interpreted it to mean complete diversity. We have an example here with Cardin versus Arcoma Associates, where complete diversity is when all the plaintiffs are domiciled in different states than all the defendants. So all the plaintiffs on this side of the verses need to be different from all the defendants on that side of the verses. And if complete diversity is lacking, the term of art that we use for that is it destroys complete diversity. That term destroys is very important when it's going to come to our test. Let's talk about domicile because that's part of diversity. So domicile for an individual, and then there's domicile for a corporation, and then there's domicile for foreign individuals. Let's talk about each of these individually. Domicile for an individual, we have Gordon v. Still, and we learn what the test for domicile is. It is, first, is that you need to have physical presence in that state, and second, you need to have an intent to remain there indefinitely. Partnerships and unions are going to follow this test for an individual domicile and not follow the corporation test. The corporation test, for purposes of subject matter jurisdiction, is that you look at the principal place of business, and then you look at the state of incorporation. And Hertz Corp versus Friend defines how we figure out what the principal place of business is, and that's going to be the nerve center or the headquarters of the corporation as long as there isn't any fraud. As far as foreign domicile goes, we have Redner versus Sanders, where a U.S. citizen was living abroad and how this all works. So 1332A subsection 2 says that doesn't say anything about the Supreme Court, or rather federal courts hearing cases related to U.S. citizens residing abroad. They could still file in state courts, but not in federal courts. Foreign internationals, though, residing within the United States, are considered citizens of that state for domicile purposes only. So if a person from Canada is residing in Iowa and then is sued in Iowa, they are technically considered Iowa citizens for a domicile purpose. Amounting controversy now, when it comes to diversity jurisdiction, is currently set to exceed $75,000. That means in order to meet the amount in controversy, you need to have $75,001 at least. We have two cases here, Diefenthal versus CAB, and then St. Paul Mercury Indemnity Co. versus Red Cab Co. All this is just saying is that if the plaintiff's claim was made in good faith, the amount in controversy is met unless if there is a legal certainty that the amount in controversy would not be met. So in other words, good faith and a lack of that legal certainty means that the amount in controversy is going to be met. We have claim aggregations, meaning that people can combine claims. Plaintiffs can combine claims against a defendant to actually find the amount in controversy. But there are lots of rules that go with this. I'll just read through these rules quickly. So a single plaintiff can aggregate claims against a single defendant. A single plaintiff cannot aggregate claims against several defendants, even if the claims are related. Multiple plaintiffs can aggregate claims against a single defendant if one of the plaintiffs meets the requirements through supplemental jurisdiction. And then finally, multiple plaintiffs cannot aggregate claims against a single defendant if neither could state a claim alone, and that is going to be the case even if one of those is related. So ultimately, claims need to be related. One person needs to meet that amount on their own, and it can't be done against multiple defendants. And that's diversity jurisdiction in a nutshell. Let's move on to supplemental jurisdiction. Note all these three things so far are still underneath subject matter jurisdiction. First case for that is United Mine Workers versus Gibbs. Excuse me for just a moment. So supplemental jurisdiction is found in 28 U.S.C. 1367. The first case that found supplemental jurisdiction was United Mine Workers versus Gibbs. There are three parts to this. There's subsection A, B, and C. Subsections A says that any state claim that is part of a case that is related through the common nucleus of operative fact, meaning that's just of the same fact pattern, they can make it to supplemental jurisdiction if they tag along 1331 or 1332. What this means is that all supplemental jurisdiction cases are going to be state law claims that weren't able to make it on 1332 on their own, and they just really need to combine with a 1331 or 1332 to apply. Subsection B says that for plaintiffs, for diversity jurisdiction, supplemental jurisdiction is not going to override complete diversity. But that doesn't say anything about the amount in controversy. So we just talked about 1332. There's those two requirements, complete diversity and the amount of controversy. 1367B is just saying we can't override the complete diversity part of that requirement. But it doesn't say anything about the amount in controversy. Sandri Ramos versus First Bank Corp. outlines the exceptions. So 1367C are exceptions where a federal court can actually dismiss supplemental jurisdiction claims. Note they can't dismiss 1332, but they can dismiss 1367 cases if it meets any of the following reasons. So first, if there's a complex state law. Second, if there's a state law claims predominate over the federal claims. Third, if the district court dismisses all the federal claims. And fourth, if they have any other compelling reason to deny jurisdiction. All those things are ways that a federal court can dismiss supplemental jurisdiction claims. So that's subject matter jurisdiction. Just to recap, you have 1331, federal question, 1332, diversity, and 1367, supplemental jurisdiction. Let's move into personal jurisdiction. You can find personal jurisdiction through four ways. There's specific personal jurisdiction, general jurisdiction, transient or tag personal jurisdiction, and consent and waiver. And we're going to go over each of these things really quickly. Let's start with specific personal jurisdiction. Our rule for specific personal jurisdiction, this comes from International Shoe Co. versus Washington. And it just says, for the plaintiff to find specific personal jurisdiction, the plaintiff's claim needs to arise from or relate to the defendant's sufficient minimum contact with the forum state. And we'll get into more of that throughout these cases. An overview of this rule, we started off with Penoyer v. Neff. This was the old rule where you had to be within the state, all the in rem, all the in personam, all that kind of stuff had to be serviced to a person within state boundaries. And International Shoe Co. versus Washington changed that, saying if the defendant has a sufficient minimum contact, then with the forum state, then they can find specific personal jurisdiction there. Schaefer versus Heitner is pretty much taking in rem cases, such as something related to Penoyer, and it turns it into following the same international shoe rule. So Schaefer versus Heitner pretty much is only saying that we're going to follow the international shoe rule, which says we need to find sufficient minimum contacts. It really is just saying in rem and in personam is the exact same thing. So what are contacts, or really how do we determine what contacts are? Let's start with long-arm statutes. So the Federal Rules of Civil Procedures, Rule 4K 1A says that the federal courts are just going to follow the state's long-arm statutes, and we have a couple of cases that outline what these state long-arm statutes are. So we start with McGee versus International Life Insurance Co. Our big takeaways from this is that California's long-arm statute extends to due process. So you can think of it as due process being this big circle, and then each state has the statute that says how big their specific personal jurisdiction is going to extend within that federal requirement of due process. So California says that their circle is going to be as big as due process allows. And that's one of the big takeaways from McGee. The other big takeaway from McGee is that even one contact is going to be sufficient to find specific personal jurisdiction within the meanings of due process. Then we have Buchanan Restaurant Co. versus King, and New York's long-arm statute is really going to be like a short-arm statute, where it's a tiny circle. And so even though the due process clause allows a big thing, New York is much more restricted, as well as Florida is also much more restricted in what it allows for finding specific personal jurisdiction. And then we have foreseeability with contacts, and we learn from Worldwide Volkswagen versus Woodson that foreseeability is not enough to find SPJ. Instead, the defendant's conduct with the forum state is what we need to look for. We learned from Burger King versus Rudzowicz that contracts are considered sufficient contacts as long as you're looking at the defendant's context and the defendant's conduct with the forum state. So a contract can be sufficient if it is related to the forum state. And then we have stream of commerce with Asahi Metal Industry Co. versus Superior Court of California. From here we have two concurrent opinions, and cases are free to use either of these. Note, we had just talked about earlier that foreseeability is not enough, but there is a difference between foreseeability and being aware of your conduct. So if a defendant, underneath the Brennan approach to this, if a defendant is aware of the marketing and sales that are going on with the forum state, then it can be sufficient to determine SPJ, but it also needs to be reasonable. The O'Connor approach says that awareness isn't enough. The defendant needs to actually take more direct action and conduct of marketing sales with the forum state. And then once again, it must be reasonable. Big takeaway from this case is that if a person meets the O'Connor test, they will also meet the Brennan test. But the Brennan test is easier to meet than the O'Connor test. We have several more recent cases of specific personal jurisdiction where we're talking about arising from or relating to the defendant's conduct. And those is going to be Keaton versus Hustler Magazine Inc., Calder v. Jones, Walden v. Fiore, Bristol-Myers Squibb Co. versus Superior Court of California, Ford Motor Co. versus Montana 8th District Court. And then finally, we finish with the internet with the verdict versus the Superior Court. And with that, there's actually a test there where we do this balancing effect to figure out. That's called the Zippo test, where passive websites and active websites to determine whether or not they're actively doing business within that forum state. And so that is specific personal jurisdiction. Let's go ahead and move into general personal jurisdiction. So the rule for general personal jurisdiction is that a plaintiff can file a claim in the domicile state of the individual or corporation who is the defendant. Once again, we're looking at the defendant's action here, and their action being where they currently reside. So we've talked about domicile with subject matter jurisdiction. But let's talk about it in the sense of general personal jurisdiction. For an individual, the test is going to be the same, where you need to be physically present and you need to have that intent to remain indefinitely. But for a corporation, it's slightly different. So for a corporation, yes, you still need to have the principal place of business. We learned about that in Perkins versus Baguette Consolidated Mining Co. This was the first case where principal place of business was actually allowed as a place of domicile. And once again, from subject matter jurisdiction, we learned that the nerve center is the principal place of business, and that's the headquarters. So you can find it in the principal place of business, the state of incorporation, or where the defendant is essentially at home. And essentially at home, to determine whether someone is at home, you need to look at the percentage of the cells and the percentage of the employees in that forum state, and you need to compare that with the rest of the world. Ultimately, we figure out there's no set number, but for our purposes, the set number is going to be at 90%. The cells and employees need to exceed 90% in order for them to be determined essentially at home for matters of general personal jurisdiction. We also need to note one last thing, that we have Helicopteros de Colombia, SA versus Hall, is that you don't want to mix up general personal jurisdiction and specific personal jurisdiction. You need to make sure that you are making proper claims because they are different. So that's general personal jurisdiction. Now we have transient personal jurisdiction, or TAG jurisdiction. And we have one case here. It's Burnham versus the Superior Court. And so a person is within TAG jurisdiction if they are physically present in the forum state. Or to say this in a different way, actual service and summons, so notice, needs to be given to the defendant while they're physically present in that state. Later, we're going to learn that venue is a limit on transient jurisdiction, but other than that, transient is pretty straightforward. If the defendant's passing through the state, and if you provide service and summons on them from that forum state, they're subject to transient jurisdiction. Consent and waiver is also pretty straightforward. Consent can happen in one of several ways. You can just appear in court, and you don't really argue with jurisdiction. Your conduct can determine that you consented. There are forum selection clauses, which say that you're consenting to jurisdiction. Or you can actually conduct business with the forum state, and that's going to be determined of business. That's going to determine consent. Consent is going to overpower any other form of personal jurisdiction that we've talked about thus far. It's going to be more important than specific or general personal jurisdiction. If you consent to jurisdiction, you pretty much waive that right to argue that argument. Or you could waive it, like we talked about earlier, when you file a motion to dismiss a 12B, in this case 2, if you don't raise a 12B2 motion to dismiss, and then you waive that right because you didn't do it right away. And that sums up personal jurisdiction. So thus far we've talked about subject matter jurisdiction, and we've talked about personal jurisdiction. So we've talked about a 12B1 and a 12B2. And now we're going to get into a 12B3 motion to dismiss for improper venue. The way I like to think about venue, so if you were looking at the United States from above and you zoom in, and say, for example, a car accident had occurred in Iowa, And so you can find a specific personal jurisdiction in Iowa and general personal jurisdiction in Iowa because the person's living there, all that kind of stuff. You notice that the defendant's conduct is centered in one state. But for venue, you actually have to zoom in closer. And you'll notice that there are grid lines in between the state. And you'll notice that the car accident happened on one side of those grid lines. In Iowa, there is the northern district and the southern district. And if the car accident happened in the southern district, well, then you need to sue in the southern district. Because if you sue in the northern district, well, then that would be improper venue. But say, for example, the person's living in the northern district and the car accident happened in the southern district. Well, according to the venue rules, you could sue in the northern district because the person's residing there, or you could sue in the southern district, and both of those places are going to be proper venue. And how does this all work? Well, the venue is described in 1391B. And there are three subsections here. So there's 1391B1, 1391B2, and 1391B3. 1391B1 applies to situations where there is only one defendant, or if there's multiple defendants, they live in the same state. If they live in the same state, you can find proper venue in any district where they currently reside. So say there are two defendants in Iowa, you can find proper venue for a person residing in the northern district and a person residing in the southern district. Say you have two defendants, one from Iowa in the northern district and the second from Wisconsin. You can't actually find this because they are residing in different districts. There would be improper venue to do it for one of those situations because this statute says that all the defendants need to be living within the same state. If they aren't living in the same states, or if you can't find it through 1391B1, you can still find it through 1391B2. So 1391B2 tells you that you can find proper venue in any place where a substantial part of the claim arises from. So, for example, if there's a car accident that happens in the Southern District of Iowa, a substantial part of the claim arose in the Southern District of Iowa, and that's where you can find proper venue. In 1391B3, just says that if you can't find it through B1 and B2, then all you have left is B3, and this just says you can find proper venue anywhere where there is personal jurisdiction. All these things ultimately is 1391B3 is only going to apply to foreign individuals. Along with venue, you have transfer. And transfer and venue are interrelated because you can transfer from a proper venue to another proper venue, from an improper venue to a proper venue, or if there's improper venue with lack of personal jurisdiction, you can transfer to a proper venue. Let's talk about each of the transfer rules. So if it's filed in a state court and you want it to be litigated in a different state, well, what's the process for getting there? First, we need to remove. We haven't talked about removal yet, but we'll get there. You need to remove from the state court to the federal court, and then you need to transfer from the federal court to another federal court. All of this is going to be from a federal district court to a federal district court. Can't transfer to an appellate court. That would be pretty much an appeal. Can't do that. These rules are outlined in 28 U.S.C. 1404, 1406, and 1631. 1404 is transfer from a proper venue to a proper venue. 1406 is a transfer from an improper venue to a proper venue, and this is actually an alternative to a 12B3 motion to dismiss for for improper venue. A lot of courts actually prefer a 1406 transfer, and the reason for that is because it's more efficient, it's less paperwork, they're going to refile anyways, all that kind of stuff. A 1631 is where you transfer from improper venue and have lack of personal jurisdiction to a proper venue. And this is just the plaintiff saying, look, we messed up. Our statute of limitations is about to run out. We need to just have this transferred. We're sorry we messed up, but can we send this to the proper court so we don't need to worry about the statute of limitations? So how do you determine whether or not you actually want to transfer? What are the courts going to consider? Well, the courts are going to consider both public and private factors. What are these private factors? Well, the private factors that the court considers is the plaintiff's choice of forum, the defendant's choice of forum, whether the claim arose elsewhere. We're going to look at the convenience of the parties, the convenience of the witnesses, the ease of access to evidence. And ultimately what we're learning from this is that all the private factors are going to be related to the evidence. Where is the evidence located? How easy is it to get to the evidence? And if the evidence is easier to get to elsewhere, well, then these private factors are more likely to be met. What about the public factors? Well, we're going to look at the transferee's familiarity with the governing law, meaning where is it being transferred? How familiar are those courts with the law? That's going to be focused on. We're going to look at the dockets to see how congested the court system is. A lot of the times, if they're transferring, those court systems are going to be less congested. And then we're going to look into the local interest in resolving local conflicts. I'm not sure if I mentioned what case is associated with this, but that's McMunn versus Eli Lilly Co. This case here, the parties wanted to transfer from D.C. to Massachusetts, and these were the factors they considered. We have another case, Smith versus Colonial Insurance Company, and the courts are not going to consider transferring for simply the convenience of attorneys. It's a pretty funny case. I recommend reading it if you haven't read it. It's really short, but quite humorous. Also with transfer, we have forum nonconvenes, and we have here Piper Aircraft Co. versus Reno. Once again, it's a pretty straightforward case. Lots of stuff going on in Scotland, and our big takeaway from this case is that if there's a sufficient forum abroad, and it makes sense for the case to be filed there, then the court has this common law rule. It's the only common law rule where you can dismiss, where they are allowed to dismiss, and so the case can be refiled abroad. And the reason for that is because you can't transfer to a foreign forum, and so you need to dismiss so that it can be refiled there. And so forum nonconvenes is going to be used only for forum cases. Sorry. Okay, we only have a couple things left to go about. There are only 3 categories left. We have notice, and then we have removal, and then there's choice of law. But like I said, I won't be getting into choice of law. I'll give an overview of what choice of law is, but I won't get into the rules. I will be going over choice of law just afterwards, and so you can find that podcast episode shortly after, but it won't be in this section. Okay, so notice. What is the big purpose of notice? Well, people need to know that they're being sued. So how does this procedure for notice work? Well, first, as we were mentioning at the very beginning, you need to file a summons and a complaint, and this is done by the plaintiff. First, you file the complaint with the court, and second, you serve the file stamped copy along with the summons to the defendant. Those 2 things need to be served in order for proper notice to be given. After that, the answer is given within 21 days of the defendant being provided notice. And then along with that, the defendants are likely to file the Rule 12B, motion to dismiss. As a side note, before we get into what counts as proper notice, we will never want to do this, but this is called a collateral attack. So in theory, if one person is sued in a state and they default, they can pretty much argue for that case to be dismissed. So say someone is sued in Alaska, they default in Alaska, and they're trying to collect in Arizona. So the person needs to come from Alaska to collect in Arizona. And at that point, the only thing that the defendant can argue is they didn't have jurisdiction in Alaska, so they couldn't get an actual ruling up there. And because of that, they can't actually gather anything here. A lot of the time, this is going to happen when a defendant wasn't given proper notice, or if a person ignored their notice and came to a lawyer late. So ultimately, this is my last-ditch effort to save this case, and you never want to do it as a proactive thing, and ultimately it can be considered malpractice if you do. So we have one case here for notice. It's Mullane versus Central Hanover Bank and Trust Co. And we learned what the constitutional standard of service is, what is considered sufficient notice, and it's going to depend on the circumstances. The best way that you can do it is through in-person. This is going to be done through a processor, and they're going to provide a certificate of service. The second best way to do it is through mail. The third best way to do it is through publication. And you would only do it through publication if you don't have the addresses and all that kind of stuff of all the other parties. And so that's our order of preference. In person, by the mail, service of publication. In Mullane, it was done by service of publication, where it could have been done in the mail, and so it was unconstitutional because they didn't provide notice. And ultimately, that is your 12B, 4, and 5 motions to dismiss, because it's insufficient service or insufficient service of process. Okay, finally we have removal. We've got one case for removal. It's Avis versus Amico Production Company. And we have several statutes related with removal. That's sections 1441, 1446, 1447, and 1448. Our big takeaways here is that state courts, so complaints can be filed in a state court. And if it's a claim that can be filed in both the state and the federal courts, then the defendant has the option to remove it to a federal court. However, any removal to a federal court must be located where the county is located. So their state court needs to be located in the state county. The federal district court needs to be in that county as well. So once there's the complaint, you don't want to answer it if you want to remove. And the reason for that is because if you answer it in a state court, well, then you've waived your right to remove. Instead, what you're going to end up doing is that you're going to go to the federal court and file a notice of removal. And this is going to be CC'd and sent to the state court clerk. And then they're going to notify the plaintiffs to say this is going to be done in a federal court. You have 30 days to remove. However, it is important to note that an answer is due typically within 20 to 21 days. And so really you only have 20 to 21 days to remove because you don't want to default. If you default, that is bad. So all claims that are made on the complaint at that point are going to be removed, and any claims that are not eligible for removal will then be remanded back to the state court. So for example, you have a 1331 claim, you remove it, after it's been filed in a state court, so you remove it to a federal court. Along with that were several state claims that don't meet diversity, and the courts, for some reason, 1367C, don't really want to listen to those cases, so they remand those cases back to the state court. If it's first filed in the federal court, then you dismiss those cases instead of a remand. Our final thing to know is that we have the forum defendant rule when it comes with removal. And what happens here is that, so a defendant is sued in their home state. If they're sued in their home state, they can't remove to a federal court within that state. So if a person is from Nevada, sues a person in Utah, the person in Utah, if they were sued in a state court in Utah, can't remove to a federal court. And the reason is because removal is to remove hometown bias. But if you're sued in your home state, well, then there's already no hometown bias, and so there's no need to remove. The thing to note with that, though, is that only applies into diversity jurisdiction, not federal question. Federal question jurisdiction can always be removed, but diversity jurisdiction claims, if it's falls under this forum defendant rule, cannot be removed. So that's removal. Let's just give an overview of choice of law. Like I said, I haven't reviewed this too much, but I do just want to say how choice of law works. So if it's a state claim in a federal court, federal courts are going to use state law. And so it's really going to be, what state law do we use? And this is really what choice of law is if the parties agreed to use a certain state's law, well, then the courts are always going to use that party's law that they chose to apply. Otherwise, you're going to, for example, if you're transferring underneath a proper venue to a proper venue, well, then you use the state law of the original venue. So say proper venue is found in Nevada, you want to transfer to Pennsylvania. Both venues are proper. Choice of law in Nevada can be applied in Pennsylvania if the Nevada law says we're going to apply Nevada law. Sometimes Nevada law says we're going to apply Pennsylvania law, or we're going to apply the law where this claim actually arose from. And so instead, if you transfer, you might end up using Pennsylvania law, or you might end up using, let's say the accident occurred in Iowa, you could be using Iowa law. And ultimately, that's just how you figure out what choice of law is you look at if it's a proper venue transferring to another proper venue, you're going to look at what the rules say of the original venue. If it's an improper venue transferring to a proper venue, you're going to use the rules of the proper venue that you transfer to. So that was a lot. Looking back now, looks like it was about 49 minutes. Not quite half an hour. It was pretty long, so I'm sorry, but that was a good overview of how civil procedure works. And it's been a joy. This semester's been pretty meaningful. So, and thanks for sticking around. I hope people listen to this all the way. But if not, thanks for listening to what you did. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.